Okay, so there's something that we have to talk about that essentially is going to become really important into the not too distant future. And in order to do that, we have to go way back in time because essentially what's happening is the Supreme Court has ruled about the status of what the court system has to give somebody when it comes to their social security benefits before they take your social security benefits away. And the reason why this is like super important is because we have Trump in office and Trump is going through the process to make people, basically really make sure that they are disabled, really make sure they are retired, really make sure they're not like some, immigrant coming from this country that borrowed a social security number illegally, yada, yada. So he's going through all this stuff. And one of the things that I need you to kind of understand is that there have been Supreme Court rulings that are not to the benefit of Social Security recipients. Now, some people say, this video is scary. Why did you make a scary video? Because if I don't wake your butt up, if I don't give you a full shoulder shake, then at the end of the day, the problem is you are going to, just putting it very simply, ignore the reality of what you're facing. During COVID, many people were like, what the F, when their benefits were just summarily removed. And there wasn't like a hearing, there was barely a notice. It was a lack of notice, really. They got in trouble for it at the SSA. Let me explain from the beginning how this all happens. Way back in the day in 1937, there was this claim called Helvering versus Davis. And the Supreme Court held that basically the federal government had the power to tax the American people these monies so that they could give them down the line potentially benefits. But at the same time, the government was allowed to change the benefits as the program needed to be modified, which meant that when they taxed the money away from you, it was under the taxation power of the Supreme Court of the Constitution of the United States. When they did that, it gave the government the power to tax your butt and not necessarily give you benefits because they could change who, what, when, where when it comes to how they give you benefits. They can make it illegal for you to receive benefits under this, and this. They could make it so that you get a reduction in benefits under this, and this. Although their main thing with that, their main weapon is, of course, the cost of living adjustment. Now, that was 1937. The Supreme Court decided that, bottom line, at the end of the day, it's merely a tax. Okay, that's what it is. Now, there was another case that came up. I'm going to give you both of them realistically here. There was Goldberg versus Kelly. Now, Goldberg versus Kelly was a case where they compared and balanced these two options of welfare versus Social Security benefits. And welfare, they decided, was needing more protection. It needed more of this, a hearing present, more notice, more this and that, because the welfare benefits, they believe to have a more severe, immediate impact on essentially somebody's life. Of course, say that to a disabled, person who can't walk, and say you're going to take away their benefits without giving them a traditional hearing. And obviously, we have a problem because that disabled person, in many ways, in many regards, should out trump a welfare person, unless that welfare person is similarly situated with that impairment. Okay. So now you get that. Goldberg versus Kelly. Welfare benefits were given protection at a higher level when it comes to removing essentially that benefit from a person, even higher protections than, for example, Social Security benefits. It wasn't until Matthews v. Eldridge, again, Matthews v. Eldridge, where basically they found essentially a situation where they said, okay, look, Social Security benefits, they do not pose the same hardship when terminated. They said welfare benefits pose a much greater hardship than when terminated. Now, remember, that was back in the day when people getting Social Security benefits usually were more financially safe. Going through multiple shitty presidents that we've had at this point, we now have most retired people in different financial categories not being able to afford the house that they paid for their entire life. So the weird part of this is that now we look back and we say, okay, Supreme Court, did you make the right choice? Obviously, now they screwed up. Major F up. Major F. The Supreme Court did a huge, huge major mistake. But during the time in which case they made the choice that welfare needed more procedural protections before they rip them away from you, they said welfare deserved more protection than, of course, Social Security benefits. But back then, the world was different. America was more stable. People had more money because the dollar was worth more. Obviously they had less dollars, but the dollar was worth significantly more. You go back to, people who are in their 80s now, they bought houses between 15 to 25,000. You go to the modern day, and most houses are between 300,000 and $1 million. So the bottom line is, right, we lived in a more financially secure, well-groomed nation. Now we live in a clown show. The circus does not know what to do with the dollar because other countries and the reserve currency, it's a problem. Other countries don't want to use us because they don't think we're going to be the big bad for the rest of time. Now, here's what I want to do. I want to go through Matthews v. Eldridge. This was the case where they threw your Social Security benefits under the bus. This was a Supreme Court case. I'm pulling this as a case brief. You can search any terms or sentences that I do. It'll pop right up. The point is, reference number is Matthews v. Eldridge, 424 U.S. 319, 1976. Okay, so the basic thing here, the Supreme Court term was 1975, 1970. No, sorry, the term of this case was 1975 to 1976. It was argued on October 6, 1975. It was decided on February 24th, 1976. Okay. Let's go through this real quick. And the United States Court of Appeals for the Fourth Circuit was reversed. Okay, so the crazy thing about this case is that the district court was like, okay, we're deciding this. The circuit court was like, yeah, it sounds pretty good. It goes to the Supreme Court, and the Supreme Court goes, no, y'all are wrong. And this case, this is why this is important in the modern day. This case is what allows them to remove your Social Security benefits before you have a true, proper, traditional hearing about the retention of your benefits. This is the case where you lost your full right to removal process of some sort of possession that you have. Right here, this is it. And don't be foolish about this thing. Be smart about it. The reason this is important, because when they start pulling benefits here and there, when they start saying, well, we're changing this schematic, we're changing this detail, now you have to have this, so you didn't have this. Remember, you were found and given your benefits back then, but if the culture of it, when it comes to proving you were still disabled, and you're still super impaired, if the culture of the SSA changes, you get some weird decisions from judges. That's why when people always tell me, like, as long as you're disabled, you get your benefits, you have nothing to worry about. I always hear that stuff from people. I'm like, all right, first of all, the person's not, really educated on the subject. They have benefits, but they don't know anything about it. And the one thing that's always weird for me is you get non-legal people telling you about legal things. Ask any attorney in this field, any attorney in any field. Judges are all over the place. You never know when a judge is going to like a case or not like a case. Just because you feel a judge is going to love a case doesn't mean that they're going to love a case. You could have the hearing, the claimant could say something horrific, and then the claim is dead. So there's always that factor of not knowing when the judge is going to be on your side, when the judge is going to like that claim. And that's the other thing too. A lot of claimants, they'll focus on my medical evidence shows this. There's so many more, not just factors, categories of factors that decide whether or not you get approved going forward. But again, the video is not about that. It's about a Supreme Court ruling. Let's get into it. Matthews v. Eldridge. In a case decided on February 24th, 1976, which is going to become hyper relevant now that Trump is in, by the United States Supreme Court, in which the court held that the termination of disability benefits prior to an evidentiary hearing does not violate an individual's due process rights under the Constitution. Let me spell that out in simple English. They can cancel your benefits, right, without having to have a traditional evidentiary hearing, because the Supreme Court previously ruled in Goldberg v. Kelly, and then again with Matthews v. Eldridge, that at the end of the day, you have less of a right to your Social Security benefits than welfare recipients have to their benefits. Welfare recipients are more protected by their right to benefits than you, the benefits you paid for, the money you paid in your entire life. Welfare recipients have a higher right to their benefits than you. That's what this video is really, and the reason I'm doing this video is to I need you to understand it, because things are going to get a little rocky with the SSA in the future when it comes to who's really disabled, who's not, stuff like that. So I need you to be aware of this, okay? All right, let me read it again. Matthews v. Eldridge, in a case decided on February 24th, 1976, by the United States Supreme Court, in which the court held that the termination of disability benefits prior to an evidentiary hearing does not violate an individual's due process rights under the Constitution. So what they're saying is they can cancel your benefits before an evidentiary hearing, and that's allowable because you don't have an immediate, severe impact if you were to lose your Social Security benefits. This was, of course, decided in 1976, where, essentially just clarifying things. They'd already come out with retirement benefits in the 1930s. They'd already come out with the SSDI benefits in the 1950s. They were just coming out with the SSI benefits in the 1970s. But people were doing somewhat okay during that time. It's not like the modern day where we're 36 trillion in debt. The average person can't afford an apartment after they've lived in a home their entire life that they paid mortgage on their entire life. All right, here we go. So, in the case opinion, the court developed a three-part balancing test known as the Matthews v. Eldridge test. Don't F around. You need to know what this test is, because this test helps you understand what could happen if they are, the SSA, unhappy with you. If they want to remove your benefits for some reason, if they want to reduce your benefits for some reason, if they want to give you an overpayment for some reason. This is part of the test as to your rights or lack of rights when it comes to keeping your Social Security benefits. Okay, here we go. Matthews v. Eldridge test for lower courts to apply when determining whether or not an individual has received due process during administrative proceedings. Okay, so the question is, did you have due process before they removed your quasi right to these Social Security benefits? Because remember, you don't have a full right. 1937 court said, bottom line, it's a tax. They're allowed to change the program as they want to, when they can, when they want to, etc. Let's keep rocking through this. Highlights the case. George Eldridge received notice of the upcoming termination of his disability benefits prior to the opportunity for an evidentiary hearing. So the SSA said, hey, we're killing your benefits. We're taking them away. And he's like, you owe me a hearing, buddy. I have a right of due process here before you remove my benefit. Eldridge argued that the termination of his benefits without a hearing violated his due process rights. The issue: does the absence of an evidentiary hearing prior to the termination of disability benefits violate an individual's due process rights? The district court said, yeah. The circuit court said, yeah. The Supreme Court surprised the F out of all of us. Here we go. The outcome. The U.S. Supreme Court reversed the decision of the United States Court of Appeals for the Fourth Circuit. So remember, district court, circuit court, Supreme Court, okay? This thing made it all the way to the people that show up in the news that are there for the big speeches, the address the nation speeches, those big ones that the president does where they're sitting up in the front row. These are those people. It made it to the highest level of our judiciary, okay? All right, so the Supreme Court reversed the decision of the United States Court of Appeals for the Fourth District and held that the lack of an evidentiary hearing prior to the termination of disability benefits does not violate an individual's due process rights, okay? Why it matters. The court developed this three-part balancing test known as the Matthews v. Eldridge test. For lower courts, that means district, circuit, stuff like that, to apply when determining whether or not an individual has received well, technically it doesn't mean appellate courts, but they review it anyways. But whether or not an individual has received due process during administrative proceedings. Now, what is due process in super simple? A lot of people don't know what let me give you the definition of it, but then let me give you what it actually means, because a lot of people are the due process. Hold on, let me pull this up real quick. Due process is a fundamental principle of fairness in legal matters, ensuring that all legal procedures are followed to protect against arbitrary government actions and to ensure fair treatment in the courts. It guarantees an individual a chance to defend their hearing rights and have a fair hearing. All right, let me put it to you another way. They needed a phrase to represent that the judiciary and the process of taking things from you was fair, and they called it due process because that's what the legal industry does. They take complex situations, they tag them, they hashtag due process that puppy, and then they just create, a doctrinal theoretical assessment of this knowledgeable 5-part test and blah 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 blah. Then they throw some stuff together to make it make sense under the legal doctrine. Okay, but due process just means they feel that they've given you enough fairness in the adjudication of your problem. Okay, that's where it stands. All right, so here we go. Matthews v. Eldridge test, lower courts. Courts must consider one, the private interest at stake. Okay, what is your interest at stake? Two, the effect on the private interest in the event of an erroneous determination, as well as the value of any additional procedural safeguards. What are they taking away from you? How valuable is it? What are the safeguards that they're putting in place while you're driving that speeding car towards a problem? Did they put up a sign that there's bumps ahead? Did they put up a sign that there's a cliff ahead? Okay. And element 3, the government's interest, including the potential administrative burden of additional procedural safeguards. How much does the government have to spend to give you a fair shot at being heard and given due process before they F you over and take away the benefits or allow you to keep your benefits? Real quick, Cyber Katie, thank you for doing, it's amazing. Sent 5 Social Security Disability Benefit memberships. That's amazing. Super amazing. Nikki H, David Johnson, Mike Falderoff, Tony, Alexio, Amy Elrod. Welcome to the membership. That's absolutely amazing. And please remember to like and subscribe with this channel. If you like these videos, if you want to know how your benefits work in the court system, which is going to be really important with Trump, you know what I mean? And Frank Bisignano, the new commissioner, a little like and subscribe so people know it exists. You know what I mean? All right, here's the deal. Let's go through them again. These are the 3 elements that decide whether or not you get to have proper due process to keep your benefits if the SSA wants to take them from you. Which, remember, there was, like, you go back 15, 20 years ago, people were like, the SSA can't take my benefits away. And now, now people they're aware. They know that not only can they take them away, they can hit them with overpayments. There's lots of overpayments due to the federal government. A lot of people feel it's totally unfair. It's just people know now that this is not a traditional like benefit for life like it used to be. Retirement benefits, for the most part, still retain a lot of that, but like disability benefits, people are going to be fighting to keep their disability benefits much more aggressively in the future. When AI takes over a lot of the assessment, reads through your medical documentation, well, let me explain something with that real quick. Artificial intelligence needs a couple of things in order to quickly adjudicate whether you should continue to receive disability benefits. They need, one, access to your medical records, which, you guessed it, they now have a medical record sharing system, just like they have a payroll sharing system, which means that, AI can suck right through all those documents, figure out if you're getting any better, etc. And it red tags every time your doctor says, we tried this medication, it showed improvement. Okay, we did this surgery, they're now able to do this. It red tags all that stuff and says, hey, this person has improvement, therefore they should be going through a CDR. So that's the future. Like, that's where we're going with this whole thing. All right, here are the elements again that decide what level of due process you should have when going forward. Okay, so here we go. Number 1, courts must consider the private interest at stake. What are you going to be losing if they take away your benefits? What is the private interest at stake? Okay. Next one, 2, the effect on the private interest in the event of an erroneous determination, as well as the value of any additional procedural safeguards. If they take it away from you, what's going to happen to you? What are additional safeguards they can do to give you more due process, a more fair adjudication? Like, what's the value of them? What's the weight of them in you being able to have a more fair adjudication before the Social Security Administration? Well, technically, it's above the SSA. It's district, circuit, Supreme Court stuff. Number 3, the government's interest, including the potential administrative burden of additional procedural safeguards. That is that's the shittiest element out of all of them. What that element then asks is, how much money does the government have to spend before it takes away your right? It says, well, look, okay, it would be nice if we can give them this procedural thing and that procedural thing and do this for them and that for them. But what's the government's interest in all of this? Does the government really care that much? Including potential administrative burdens of additional procedural safeguards. Like, how much is that going to cost? How much time do we have to spend on this person losing their benefits? I mean, do we really need to do that for them? That's element 3. Element 3 is the cleaver. Element 2 is the like, what procedures can we put in place to help this person? Element 3 is, yeah, but what's the cost associated with it? You know what I mean? We don't have to have this guy back twice. You know what I mean? Hey, you know? All right, here's the background. George Eldridge was granted disability status due to back strain and chronic anxiety in June of 1968. 1960s. Okay, let me just hold on. Let me pull up what was going on in 1968. All right, hold on. Let me pull this up real quick. What was going on in 1968? Because this is important to understand how far back this was. Oh, sorry, I put in 1068. That was a very different time. That was Norman rule in England, Battle of Hastings. We don't want that. Hold on, 1968. Oh man. Okay, so turmoil and change marked by triumphs and tragedies. The Tet Offensive in Vietnam, assassination attempt on assassination of Martin Luther King, Robert F. Kennedy, the Apollo 8 mission that orbited the moon, the Civil Rights Act of 1968, which was amazing. So that was a very, very, very upheaval-ish year. Okay, cool. Now, so 1968, he was approved. He received a letter in May of 1972 from the state agency monitoring his benefits, informing him of the agency's determination that his disability had ceased. The Social Security Administration accepted the state's agency's determination and notified Eldridge in July that his benefits would end the following month. Eldridge challenged the agency's action, arguing that the termination of his disability benefits prior to the opportunity for an evidentiary hearing violated his due process rights. Again, violated his due process rights. Now, what they won't have a lot of details in this, and what they do nowadays is they have what's called the 8-step sequential process. But that's still done by DDS. DDS is the group that decides if you are in fact still disabled under the 5-step sequential process when you first apply, and the 8-step sequential process when they do a review of you to see if you're still disabled. It's called CDR, Continuing Disability Evaluation. So here's the deal. What you need to know is this, all right? As you go through this process, I think I just quoted CDR as the wrong words, but it doesn't matter. Point is, you are literally going to be going through at some point in the future some form of CDR, because the computer systems are checking this. Only if you're in a situation where you're like super bedbound, you're a compassion allowance listing, that those aren't going to be checked into. Okay, that's not what disability benefits. Disability benefits are becoming the step below bedbound. The step where you're really struggling to walk, where you're really struggling to be able to wake up and cognitively function, stuff like that. So what happened here was 1968, this guy, George Eldridge, got his benefits. 72, DDS decided, hey, we don't think you're disabled anymore. They sent it up to the federal group, which is called Quality Control. And Quality Control said, we agree with you, DDS. We agree. Quality Control is the federal government. DDS is the state government. DDS always needs the okay from the feds to go ahead and basically, go through with it. So bottom line is Quality Control, the federal government said, yes, we agree. This person is no longer disabled. We are going to remove his benefits. And, this is not, this is it. We're just going to do it. And so he's like, well, I'm going to lose my benefits next month. What the F? What the literal F? How does that work? Okay. Now it works a little bit differently than that nowadays, but still the Supreme Court holding is what they base all this stuff on. Now, here's the deal. Eldridge challenged the agency's action of trying to cancel his benefits, arguing that the termination of his disability benefits prior to the opportunity for an evidentiary hearing violated his due process rights. And if you're just joining the channel right now, remember, due process rights are your rights that they give you before they take shit away from you. It's the fairness doctrine. How much fairness are they going to give you with looking at something, having your peers there to look at something, having an administrative body there to look at something? It's the how fair are they going to be when taking something from you, okay, that you have a quasi or full right to. Eldridge based his argument on the U.S. Supreme Court decision in Goldberg v. Kelly. Because remember, when we started this video, Goldberg v. Kelly said look, you have to have a full evidentiary procedural protection based hearing before you can remove essentially the welfare benefits that somebody has, right? You have to have a full evidentiary hearing. Okay. Now, the way it works nowadays with your Social Security benefits is that if you don't respond, they will take 50% of your benefits. If you respond, you have so much time, which is usually 10 days, which is absolute insanity, to tell them that you want your benefits to continue throughout the adjudication process. However, you don't get an actual hearing with an actual doctorate level administrative law judge until you've had 2 denials with DDS at initial filing, reconsideration, and then the ALJ hearing. But the moment you have that ALJ hearing and the ALJ decides that you are not in fact disabled, that is when they cut off your benefits nowadays. But if you don't respond within, at all, they take away 50% of your benefits now. If you don't respond within 10 days and request that your benefits be, continued throughout the adjudicative process, then guess what? They go ahead and stop paying your benefits. You have to appeal and then try to get those benefits reinstated, essentially. So it's based off of this. They improved it. But remember, when Trump wants to go forward with deciding stuff, this is a foundational case. This is important. All right. Here's what happened. Eldridge based his argument on the U.S. Supreme Court's decision in Goldberg v. Kelly, which established the right to a hearing prior to the termination of welfare benefits. Then U.S. Secretary of Health, Education, and Welfare Forrest Matthews, who delegated the administration of disability benefits to the SSA in accordance with the Vocational Rehabilitation Act of 1920, they disagreed with Eldridge's position. Matthews argued that the SSA had followed the required administrative regulations, right? They went through is this person disabled? Did they improve? Are they doing better, etc. He also stated that the Goldberg decision was not controlling. The Goldberg decision was, just to go over it one last time, was that they have to give more due process, more civil procedural rights to welfare recipients. So they argued, basically the guy here who lost his disability benefits, that Goldberg should hold. He's a special class. He's a very, very special class of individuals. Okay. He also stated that the Goldberg decision was not controlling because the process for determining disability benefits relies on medical evidence, while the process to determine welfare benefits relies on financial need. Now, that is a really shitty way for government to tell a disabled person to go F themselves. Because basically, when you tell somebody we should be able to remove your benefits because it's based off of medical restrictions and not financial need, is a really crappy way of saying, yes, you require a walker to ambulate, and we looked at your medical evidence and we understand what's going on, but the welfare people, we know they need money because they got to have money because they don't have money. Like, imagine that logic. Imagine arguing that some disabled person deserves less rights to their benefits. It's insanity, but they did it. That a disabled person deserves less rights to their benefits because the SSA benefits are based off of how medically limited they are, how unable they are to work. Just grasp that shit. Like, understand how stupid of an argument that is, and then how crazy ridiculous it is for the Supreme Court to back it. Just let that sink in for a moment. I'll go over it again. The way it works is they argued, the Social Security Administration, that the removal of this disabled guy's benefits, okay, was acceptable without giving him a hearing first, because when they decide that he should be given benefits, it's based off of a medical decision. So true, he could have been a billionaire. Well, not back then. He could have been a millionaire. He could have been a thousandaire. He could have been a millionaire, whatever. It was based off of medical information. Now, if the Supreme Court knew how this system worked, they would know that the first element of disability is, can the person earn enough money to earn more than SGA, which, by the way, in 1972, let's see what it is. Hold on. 1972, SGA, SSA. I don't even know what it is because, who the hell knows what that is? Let's see what we got here. Hold on. Let me see if I can find a chart real quick on this puppy because, here we go. All right, 1972. I got this giant graph. 1972. Hold on. It was $140. If you could earn more than $140 per month in 1972, then you were not disabled. So just to be clear, in order to get SSDI benefits, you could have $1 million in the bank, but your ability to earn money going forward is limited because the first element and the fourth element and the fifth element of the 5-step sequential process, the 5 elements of getting disability, require that you can't work at a certain level. You can't earn at a certain level per month. So the Supreme Court effed this all up. They completely screwed this up because at the end of the day, when a person goes ahead and is disabled, we're saying that they can't earn enough money to actually live a decent life. Now, they argued they don't care. They argued on behalf of the Social Security Administration that the person could be rich. They just wouldn't necessarily be able to use it in their application. Whereas a welfare person is always poor because they're always poor because that's their main financial review. That's their argument. My argument is how many multimillionaire disabled people are out there that continue to remain and grow wealth because they have the money, they've invested the money, and it doesn't matter if they work. To me, it is moronic at the highest levels. If I were on that Supreme Court, I would have dissented so hard that they would still be talking about it today, like we are. All right, let's keep rocking and rolling. So here's the deal. All right, he also stated that the Goldberg decision was not controlling because the process for determining disability benefits relies on medical evidence, while the process to determine welfare benefits relies on financial need. That is an incorrect assessment. Disability benefits are only given to people who are unable to work, which is a financial factor. Element 1, Element 4, Element 5. Element 1, can you earn SGA? Element 4, can you do your past relevant work? Element 5, can you do relevant, transferable, skilled, semi-skilled, or unskilled work? 3 elements of the 5 elements we use to decide if somebody is disabled. 3 out of the 5 are about your work ability. Ergo, your financial ability to survive. You know what I mean? And it's like, what the F? That's why I get so upset, because a lot of these Social Security rulings are just like weird because they don't know the program. The district court ruled in favor of Eldridge. District court said, arguing that the interest of the disability recipients in receiving uninterrupted benefits was indistinguishable from that of the welfare recipients. The court claimed that the agency had violated Eldridge's due process rights by failing to hold an evidentiary hearing prior to the termination of his disability benefits. The United States Court of Appeals for the Fourth Circuit affirmed the lower court's ruling. So what happened was the district court said, yeah, we think a disabled person has a pretty, and I'll quote, immediate and severe impact if you take away their benefits. Circuit court said, yeah, we think so too. That makes sense. I mean, the Supreme Court came in and said, nah, nope. Decision. The United States Supreme Court reversed the lower court's ruling in a 6-2 decision. Justice John Paul Stevens did not take part in the decision. The majority opinion was written by Justice Lewis Powell and joined by Chief Justice Warren Burger and Justice Byron White, Harry Blackmun, Potter Stewart, and William Rehnquist. Justice William Rehnquist, a lot of his decisions are really interesting. Justice William Brennan issued a dissenting opinion, which was joined by Justice Thurgood Marshall. Thurgood Marshall did a lot of amazing decisions. Opinion of the court. The court held that the termination of Eldridge's disability benefits prior to an evidentiary hearing did not violate his due process rights. The court reached its conclusion by developing a 3-part test to determine whether or not an individual has received due process during administrative proceedings. Quote, resolution of the issue here involving the constitutional sufficiency of administrative procedures. Administrative procedures are like, Social Security administrative adjudication procedures, where they're like taking away an administrative benefit. So, resolution of the issue, they're deciding the issue here, right? How it's going to be decided in the future, involving the constitutional sufficiency. Did they give enough rights and freedoms to the person that it meets the constitutional due process? Like we gave them a fair shot to like keep their property, keep their benefits, keep their right, keep the quasi right to that thing that they are owed, right? So, involving the constitutional sufficiency of administrative procedures prior to the initial termination, when they're going to cut your benefits off, a benefits and pending review requires consideration of 3 factors. These are the 3 factors that decide whether or not you have essentially enough due process with them cutting off your benefits. Number 1, the private interest that will be affected by the official action, right? Very simple. What is the thing that they're cutting off? Number 2, the risk of an erroneous deprivation of such interest through the procedures used and probable value, if any, of additional procedural safeguards. What safeguards, what provisions do they have to use to decide if they're going to take away your benefits? And should there have been more? Element 3, the government's interest, including the fiscal and administrative burdens that the additional or substitute procedures would entail. Is it going to cost the government too much to give you enough of a fair shot to keep your benefits? Just take that for a moment. Element 3, does the government have to spend too much on you as a disabled person being able to argue in a hearing that you should keep your benefits? Just let that sink in, okay? Also, please remember to like and subscribe. Hit that like button. Don't be afraid to hit it. Since hearings concerning disability benefits rely heavily on standardized medical documentation, the court found that such hearings are of less value than those concerning welfare benefits. Moreover, the court determined that the appeal process provided Eldridge with full access to the information in his case and afforded him ample opportunity to submit additional evidence. Writing for the majority, Justice Lewis Powell further argued that creating a requirement for an evidentiary hearing before the termination of each disability benefit case would create an administrative burden. So to understand that, the Supreme Court decided that you, a Social Security recipient, are not worth an evidentiary hearing up front when they try to take away your benefits. I just need you to know about this because we do have Trump in office. I'm not saying good, I'm not saying bad. It's just, remember, they're going to be reviewing a lot of people to see if they're really disabled. They're going to be reviewing, for fraud, similar fault, things like that. So just be aware. This is what the Supreme Court decided. The Supreme Court said, we do not believe we should be giving people that a full evidentiary hearing for a benefit that they paid their entire life into. We do not feel that we should have to give them an evidentiary hearing. Absolute disgusting insanity. Moreover, the court determined that the appeal process provided Eldridge with full access to the information in his case and afforded him ample opportunities to submit additional evidence. Writing for the majority, Justice Lewis Powell further argued that creating a requirement for an evidentiary hearing before the termination of each disability benefit case would create an administrative burden. Yes, you get the opportunity to see what's in your record. Sometimes now you can't get a hold of the SSA to send you the e-folder. That's just the ERE, output. It's sad because, the SSAs, they're having a lot of people leave and they're reshaping it. It's tough to work with them right now. Okay. But what's interesting about this is welfare people are given a right to a hearing. How many people, let's look, how many people are on welfare in the United States? I'm curious. How many people are on welfare in the United States? Okay, let's just do a numbers comparison. Okay. Approximately 65 million people in the US rely on welfare programs, with about 40 million people benefiting from food stamps. Okay. So, all right, now let's go to Social Security. Social Security, let's see, amount of people on social is 72 million. So there are just less than 10, it's 65 and 72. So we're talking about 5 and 7 million people more on Social Security benefits than welfare. Now, we have as a country become a welfare state. Like if we can look up, how many people were on welfare in 1972? Let's see what it can find. Around 7 million people. Okay, so how many people were on Social Security in 1972? Around 28 million people. All right, so there was way less on welfare back in the day, which was probably part of the reasoning for their decision. There were way more on Social Security benefits way back in the day, but now it's changed. Now we live in a welfare state. America is a welfare republic. So as a result, there's almost as many welfare recipients as there are Social Security recipients. So now the numbers argument on here would not work. The Supreme Court would have to redecide this because the numbers don't make sense with their prior 1972 decision. Quote, requiring an evidentiary hearing upon demand in all cases prior to the termination of disability benefits would entail fiscal and administrative, notice how they say specifically disability benefits. That's important there. But termination of disability benefits would entail fiscal and administrative burdens out of proportion to any countervailing benefit. The judicial model of an evidentiary hearing is neither a required nor even the most effective method of decision-making in all circumstances. And here, where the prescribed procedures not only provide the claimant with an effective process for asserting his claim prior to any administrative action, but also ensure a right to an evidentiary hearing as well as a subsequent judicial review before the denial of his claim becomes final, there is no deprivation of procedural due process. What the Supreme Court said in 1972 is that they do not have to give you a hearing when they want to take away your benefits. And that is why we have the more modern system that we have today, where DDS gets to tell you they're going to take away your benefits and get, approval from quality control in the federal government. You can appeal it to reconsideration. You can then appeal it to the administrative law judge in the OHO hearing office, in which case you have to get 2 denials before you even get the option of having a hearing, which is, it's disgusting. Okay. It is so ample in evidence how poorly we treat our Social Security recipients, not just the retired, not just the disabled, not just the disabled adult children, not just the widowers, not just the survivors. You ever think back, you ever like take a moment and think about like the difference, like when somebody becomes disabled, right? It's such a small amount of money and the benefits aren't good. You become quasi like a refugee in the United States. You ever think about that? Like, just take a moment to think about that. You are a citizen, but your ability to partake in the process of America as a capitalism model, your ability pulls you backwards as if it were like you were a refugee coming to this country, not having the ability to connect with your ability to make money. Like that's what it is. You become like this quasi refugee situation when you become disabled because you can't do and achieve the things that America is known for. The court also observed that the termination of disability benefits does not impact individuals and families in the same manner as welfare benefits. If the disabled worker's needs were to escalate, the justices argued, welfare benefits would then become available. That is incorrect. Because welfare benefits, as many of you know, and they've changed a lot of the rules since 1972, are not stackable. They are combinable where they reduce each other. So when somebody's like, oh, blah, 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 yes, you get a little welfare here and there, but for the most part, most SSDI people that are really low in what they get have to rely on SSI, which is a form of welfare, which only gets them around $1,000 a month, which is not enough to afford Medicare, which is why they get stuck on Medicaid. But is $1,000 a month enough to live on in America? No, because we've had essentially decades of crap presidents doing the absolute worst things when it comes to international trade, reserve currency, dollar value. It's just, the list goes on and on. Don't even bring up the farmers. I get too animated on that one. Quote, in the view of the torpidity of this administrative review process and the typically modest resources of the family unit of the physically disabled worker, which is just insanity. They literally say in this decision, they say that because disabled people usually have family members that will help them and take care of them, their right to basically claim that they don't have an immediate and severe need for these benefits, that they're saying that they don't actually have as much of a loss fear that a welfare recipient would. Just different times. 1972. This is the case though. This is standing in many regards still. All right, so in the view of the turpidity of this administrative review process and the typically modest resources of the family unit of the physically disabled worker, the hardship imposed upon the erroneously terminated disability recipient may be significant. Still, the disabled worker's need is likely to be less than that of a welfare recipient. In addition to the possibility of access to private resources, other forms of government assistance would become available where the termination of disability benefits places a worker or his family below the subsistence level. Now, remember, right now, there's around, hold on, let me see how many there are. How many people are on SSDI? How many people are on SSDI benefits? So there's like 65 million on welfare. There's like 9.24 million on disability benefits right now. So arguably, to give welfare recipients a hearing and then tell 9.24 million SSDI recipients that they can't have one because there's just too many of them and they got a family and the family is likely to support them. And even if they go down, they have SSI that can help get them to $1,000 a month. It doesn't make sense. It's insanity. And you got to remember, this was a decision in 1972. It doesn't make sense now. I mean, it was wrong back then, but it's epic wrong now. Still, the disabled worker's need is likely to be less than that of a welfare recipient. They're just throwing the disabled under the bus. In addition to the possibility of access to private resources, other forms of government assistance will become available where the termination of disability benefits places a worker or his family below the subsistence level. Here is the dissenting opinion. This is where a judge tears into them. And it's at the Supreme Court. In his dissent, Justice William Brennan countered the court's claim that the termination of disability benefits would not impact an individual in the same manner as the termination of welfare benefits. So this dissenting opinion is saying, whoa, hold up. Our fragile class of disabled people, Social Security recipient beneficiaries, is at the level of welfare recipients. So what this dissenting opinion from Justice William Brennan is saying, we shouldn't be throwing the disabled under the bus. We shouldn't. They should have the same protections as welfare recipients. It is quite out there when you imagine that the Supreme Court justices threw disabled under the bus in the support of welfare recipients. Because welfare recipients are based off of financial need, and they claimed that disability recipients aren't based off of financial need. But yet, 3 of the elements of the 5-step sequential process, the 5 elements of disability, are on financial ability to earn money. All right, I'm going to get off that because I get a little spicy. He argued, back to this, he argued that such a claim was speculative and illustrated his position by highlighting Eldridge's circumstances, in which the termination of his disability benefits resulted in the foreclosure of his home, among other financial hardships. Brennan concluded, finally, it is also no argument that a worker who has been placed in the untenable position of having been denied disability benefits may still seek other forms of public assistance. All right, so what did we learn from this? Okay, people lose their houses, right? Okay, people, go ahead and become homeless. People don't have food. People don't have clothing when they're disabled because they can't earn money. The reason I'm explaining these 2 cases, Goldberg versus Kelly, they gave welfare recipients a heightened procedural due process right. And Matthews v. Eldridge, they threw Social Security recipients under the bus and said they don't deserve as much of a due process procedural right, where they don't have to have an evidentiary hearing up front. The reason I point this out to you is that the number one thing that they didn't go into, that they didn't see, is that if the Social Security Administration goes into shit mode, where it takes months and years to decide things, then you have a disabled person losing part of, or all of, or potentially none of, if they, within their 10-day period, request that they continue the benefits through the adjudicated process. It's where essentially a disabled person could be fighting to keep their benefits through the initial filing level, which used to take 3 to 6 months, the reconsideration level, which used to take 3 to 6 months, the OHO hearing level, which used to take 9 to 12 months to get to that hearing. Well, that's not how it works nowadays. Nowadays, it takes 14 to 18 months at initial filing, 14 to 18 months at reconsideration, 12 to 15 months at the OHO hearing level. It takes years to get to the hearing. Think about that. Think about the immensity of the harm we are doing to people who have been adjudicated, who have been ruled unable to work. Now, some of you will correctly argue that if the person has to wait years, many of them will have to go back to work in some way, fashion, or form. It's the ultimate got ya situation that the government has figured out how to use. And it's very sad. It's very sad. With that said, I hope you enjoyed this video. Attorney Walter Hnot, most viewed, clicked on, and subscribed to Disability Attorney. If you need a disability attorney, call a bunch of them. You don't have to just call me, call a bunch of them. But main question you need to ask them is, if they were to take on your claim, how much of a referral fee would they have to pay to whatever company found you to send you to them? Also, please remember to like, subscribe, become a member if you want. But the thing I really love is when you go to Disability Resolution Law Firm on Google or Disability Resolution Florida, you just type it into Google Disability Resolution. Throw some stars up there if you like these videos, if these videos help you understand what the actual rulings were when it comes to Social Security benefits. Now, Mondays and Thursdays, I normally go live. I was really exhausted Monday and Thursday. I'm going to try and go live later tonight to answer questions for free. You know the rules, 5 to 10 minutes, or you get 5 to 7 minutes with the question, no story mode, no question stacking. Hit me right up front with your legal question, okay? You know the rules. With that said, there's a private mini contract for a private hour below, where you can always hire me for an hour to figure out a situation you're in. That's fine. But remember, anywhere from a week and a half to 2.5 weeks, they get filled up. So you might get put over there. If it's an emergency, you have to tell me right up front. Okay, because then I usually do like instead of a 12 noon, it's like a 9 p.m., it's like a 7 p.m., yada, yada. All right. With that said, I will catch you all a little bit later. You have a wonderful, wonderful, wonderful day, and I will catch you in about 10 minutes at the next video. Thank you so much, Attorney Walter Hnot, and we will go from there. Have a wonderful, wonderful day. I'm going to put the link for the next video in the chat. All right. Bye-bye, everybody. Bye-bye.